239AA establishes the Legislative Assembly for NCTD. The seats in the Legislative Assembly are filled by a direct election from the constituencies of NCTD. The Legislative Assembly of NCTD embodies the constitutional principle of a representative democracy similar to the Legislative Assembly of the state. The members of the Legislative Assembly of the NCTD are selected by the electorate of Delhi to represent their interests. Article 239AA must be interpreted to further the principle of representative democracy. To interpret the phrase insofar as any such matter is applicable to union territories in a restrictive manner would limit the legislative power of the elected members of the Assembly. The members of the Legislative Assembly have been chosen by the electorate to act in their stead. Thus, the legislative competence of NCTD must be interpreted to give full impetus to the will of the electorate. Then page 53. The principles of democracy and federalism are essential features of our constitution and form a part of the basic structure. Federalism in a multicultural, multi-religious, multi-ethnic, and multilinguistic country like India ensures the representation of diverse interests. It is a means to reconcile the desire of commonality along with the desire for autonomy and accommodate diverse needs in a pluralistic society. Recognizing regional aspirations strengthens the unity of the country and embodies the spirit of democracy. Thus, in any federal constitution, at a minimum, there is a dual polity. That is, two sets of government operate, one at the level of the national government and the second at the level of the regional federal units. These dual sets of government, elected by we the people in two separate electoral processes, is a dual manifestation of the public will. The priorities of these two sets of government, which manifest in a federal system, are not just bound to be different, but are intended to be different. While NCTD is not a full-fledged state, its legislative assembly is constitutionally entrusted with the power to legislate upon the subjects in the state and list and concurrent lists. It is not a state under the first schedule to the Constitution, yet it is conferred with power to legislate upon subjects in lists 2 and 3 to give effect to the aspirations of the people of NCTD. It has a democratically elected government which is accounted in lists. It is not a state under the first schedule to the Constitution, yet it is conferred with power to legislate upon subjects in list 2 and similar to states. In that sense, with the addition of Article 239AA, the Constitution created a federal model with the Union of India at the center and the NCTD at the regional level. This is the asymmetric federal model adopted for NCTD. While NCTD remains a union territory, the unique constitutional status conferred upon it makes it a federal entity for the purpose of understanding the relationship between the Union and the NCTD. A combined reading of Articles 73 and 162 of the Constitution indicates that the Union has exclusive executive power over entries in List 1. The states have exclusive executive power over entries in List 2. With respect to List 3, that is a concurrent list, the Union shall have executive power only if provided by the Constitution or by a law of Parliament. The states shall have executive power over the entries in List 3. However, if a central legislation or a provision of the Constitution confers executive power to the Union with respect to a List 3 subject, then the executive power of the state shall be subject to such law or provision. The executive power of the Union in a state over matters on which both states and the Union of India can legislate, that is the concurrent list, is limited to ensure that the governance of the states is not taken over by the Union. This would completely abrogate the federal system of governance and the principle of representative democracy. It is with this objective in mind that the members of the Constituent Assembly thought it fit to limit the executive power of the Union in a state over matters on which the state legislature also has legislative competence. The principle in Articles 73 and 162 would equally apply to the scope of executive power over matters which are within the legislative competence of both the Union and the GNCTD. This is because the objective of the provisions is to limit the executive power of the Union in the territorial limits where there is an elected government of a federal unit. Both Parliament and the legislature of NCTD have legislative competence over List 2 and List 3. For the purposes of NCTD, both List 2 and List 3 are concurrent lists. Thus, the delimitation of executive power between Parliament and the government of NCTD with respect to entries in List 2 and List 3 are guided by these principles. Both Parliament and the legislature of the NCTD have the power to enact laws with respect to List 2, subject to the caveat that entries 1, 2, and 18, and entries 64, 65, and 66, inasmuch as they relate to entries 1, 2, and 18, are carved out of the domain of the Legislative Assembly of GNCTD and List 3. The executive power of NCTD shall extend to all entries in List 2 and List 3, other than those entries which are expressly excluded in Article 239 AA3. Such power shall be subject to the executive power of the Union through the Lieutenant Governor only when the Union has been granted such power by the Constitution or a law of Parliament.